Right. Number four is implied conditions. So this is stated under section 16(1)(b) of SOGA, right? That is an implied condition that the goods must be of a merchantable quality. Eh? So when talking about merchantable quality, the term merchantable quality is not defined in the Act. But the case laws uh, do defines that merchantable quality as, for example, like acceptable quality or salesable quality, meaning to say uh, there is a value that the goods has the value in the market, right? In which that it can be, or they can be sold to the market, and there is a demand of that particular goods. So it is immaterial whether the goods is pre-loved or used goods or brand new. So as long as it is marketable, sellable, and has some values, so we can say that it is a merchantable quality. Right. So merchantable quality also can be defined as that the goods must not uh, in I call a good conditions, or there is no defect at all in that particular goods. So that's why if the goods has certain defects, we can say that that good is not, there's no quality in that goods. So the buyer has the rights to repudiate or to cancel the contract if it happens that the goods is no merchantable quality or acceptable in quality, right? uh, Having said that, right, in the provisions under section 16 also mentioned that provided that if the buyer has examined the goods, there shall be no implied condition as regard defects which such examination ought to reveal. So it means that even though the law prescribes that it is implied conditions that the goods must be merchantable quality, however, if the buyer has the opportunity to examine the goods in front of him before buying the goods, right, and it revealed that after the contract of sales that the goods has certain defects, so the seller is not responsible to actually uh, to what you call that the buyer the buyer has no rights to actually to repudiate the contract. So this is we call as proviso. When the general rule says that implied conditions that the goods must be merchantable quality, but at the same time it also give the opportunity for both parties, right, especially for the buyer, to examine the goods. So whether the buyer has the rights to to claim under this merchantable quality or not is depends on uh, whether he has the opportunity to examine the goods. So in other words, actually the law also give the rights to the seller actually to give the opportunity to the buyer to check the goods before the contract has been tied off. So if the contract has been entered into and the goods has been examined by the buyer, then there's no such rights for the buyer to claim the goods. Okay, number 5, implied conditions that sales by sample. So usually the contract of sales by sample is made when the goods related are difficult to be showed to the seller to due to its size, or in some cases they are out of stock and etc. So the law has actually made some conditions, implied conditions, that the good must correspond with the sample given. So if there is a breach whereby the goods doesn't match with the sample, then uh, the buyer has the right to claim, to return or cancel the contract. So by cancelling the contract, he also has the return the right to return the goods and terminate the contract. So under this sales by sample, uh, it's further stated under section 17 2A and B, A, B and C. There are three conditions in that. The bulk shall correspond with the sample in quality, in terms of quality. Number 2, the buyer has the opportunity to compare the bulk with the sample. And number 3, goods are free from any defect. Okay, so these three conditions under the sales of by sample. All right, so right, number 6 is implied warranty. So number 1 and number 5 is implied conditions. Number 6 and 7 is implied warranty. So we're talking about implied warranty, as I explained earlier, that the buyer, if there is a breach of implied warranty, the buyer has no right to cancel the contract. Instead of that, he can only claim for damages. So damages is usually in terms of money. So it's sometimes so in practice, if no money is actually given, normally the seller has to fix the goods. If anything happen to the goods. Okay. One is the buyer shall have and enjoy quiet possessions of the goods without any wrongful interference by a stranger or a third party, or even by the seller himself, claiming the rights. So the keyword here is quiet possessions. Quiet possession. So the term quiet possession again is not defined under the act. It's not defined under the act, but the cases of law uh, has explained that the term quiet possession is just like, for example, uh, I give you example, like if you buy a car, for example, right? If you buy a car, that means uh, you enjoy the full rights of that particular car, meaning to say there is no other interference from the third party. Mean, for example, like the what you call that, example, uh, example lah, like the grant, there is a problem in the grants, for example. The- there is a still whereby somebody, for example, has the right to claim that car. eh? Uh, so meaning to say, if you buy a car, so meaning to say you have full enjoy of that particular ownership of the car. There is no such interference from the along, for example, from the money lender, right? That can claim the car. So that is what you call quiet possession. Meaning to say, you as a buyer has uh, a peace, have a peace in your mind, when you buy that car. So that is what you call that quiet possessions. Number 7 is implied warranty, right? Again, stated under section 14C. So free from any encumbrances. So the keyword here is encumbrances. So encumbrances also means as charge, or if your property, we call as mortgage. So it's meaning to say, if the goods is not free, from any charge, from any, for example, from the money lender, right? Whereby the previous owner actually uh, uh, has made that goods as a collateral for the loan, for example. So it has to be free. It has to be free at the time of the contract has been made. Meaning to say, there is no such person will claim for that particular goods, on the ground of it is still on the mortgage term, or on the still charge for the loan. So if it happens that the car is still under the mortgage or something like that, the buyer has the right to claim damages. So claim damages, maybe he claim damages and then pay for that particular loan. Pay for the particular loan. Loan that has been made by the previous owner. All right. Okay, so right now we discuss the performance of the contract. So when talking about performance of the contract, bear in mind there are two main point here. One is delivery and the second one is acceptance. So what is meant by delivery? Delivery is means payment, place of delivery, cost, delivery, and time. Okay, whereby the acceptance. So what amount to acceptance is, there are three situation whereby the acceptance can be said to the on the part of the buyer. First is when the buyer intimates or hints to the seller that he agreed to buy the goods. So if he give a hint, or even if he's explicitly say that I want to buy, then it's no problem at all. But sometimes in some situations that the buyer doesn't give a response whether they want to buy or not. So that is the issue. So the law has prescribed three situations, for that particular buyer who keep silent, who keep silent, not responding whether or not to buy the goods. So one of the situation is that when the buyer himself intimates or hints to the seller that he want to buy the goods. So this is very subjective. This is very subjective, depends on the particular case. So whether a person is indirectly say that he want to buy, then if the seller can prove that particular facts, then it will say that the buyer accepts to buy. Number two, when the buyer acts as if that he agrees to accept. Okay, or in the provision it says that good has been delivered to the buyer, and he refers to buyer. He acts in a manner inconsistent with seller's ownership. So under the provisions, if you look at the model, right, it says that the goods had been delivered, and then the buyer acts in a manner inconsistent with seller's ownership. Meaning to say, if the goods, example like car, has been delivered to the buyer, okay, and the buyer, for example, in this case, has used the car uh, for many times, or for a period of times which is very long times, uh, which we can say as a normal practice that actually he wants to buy, as if that the car is his, so that is what it means by he acts in the manner uh, inconsistent with seller's ownership. Okay, number three, buyers retains goods after a reasonable time. Okay, so when the goods has been delivered and the buyer retains goods, mean to say he holds that goods after several times, which indicates that if a normal buyer, the goods would have been given back to the seller, but instead of given back to the seller, the buyer retains goods, for certain period of time lah, which we can say that actually he want to buy the goods. Maybe what is a reasonable time? It is a question of fact. So if you say that example, if you want to buy a car, and then normally uh, you know uh, most of the time that the car has been there is a test drive, so what amount to test drive, maybe one or two test one or two times only, but if you test drive for a month, or 2 months, means that it's not a test drive. It is actually something that you actually want to buy that particular car. So it's a matter of a question of fact and matter of practice, right. So okay, in the issue of delivery, in some situations, there are some situations whereby the goods are delivered, goods are delivered to the buyer, but sometimes it arises some issues. For example, number one, goods delivered, but the quantity is lesser than ordered. Okay, this is mentioned under section 37. So what happen if the goods delivered is less in terms of the quantity, as ordered? So the law prescribes that the buyer, one, either he has an option either to reject all the goods, reject all the goods means you cancel the contract, or he can accept and pay for the contract price, for that particular goods. So meaning to say, if for example, if the buyer order one car, but instead of the seller delivered one car, it delivers two cars. So either the buyer has to reject all the cars, or he accepts all cars and pay for the ini less than quantity. So if less than quantity, for example, the buyer ordered, for example, like 100 tons of sugar, for example, 100 tons, but instead of 100 tons delivered, only 70 ton delivered to the buyer. So either he want to reject all 70 tons or accept and pay for the contract price for 70 ton of sugar. So the second situation, it is opposite of the first one, whereby the goods delivered larger in terms of quantity. So this is under section 77 2. So the buyer first, either he has the option to reject all, or second one, he accept the goods ordered, only accept the goods orders, meaning to say 100 tons and then delivered 120, so he accept only 100 tons. Okay, so the remaining 20 has to return. Or number 3, accept all. Okay, accept all 120 tons of sugar. Okay, so it's up to the buyer lah. It's up to the buyer. So the 3 option here. So number 3, goods delivered not according to the description. So in this case, under section 37.3, the buyer has the right to reject all, right? Number 1, or he has the right to accept only those goods which comply, which comply to the descriptions, and reject the rest. So number 4, when the good perish, under section 7, the contract is void. Okay, meaning to say nothing can be done because the goods have been perished already at the time of the delivering the goods. So in the case of the good is perished, then the contract is void ab initio. So in this case, maybe both parties are under mistake that they don't know, that they are not aware that the goods are delivered are actually perished or damaged. Okay. Right. We move on to the transfer of title. Right. Transfer of title. So the transfer of title means that the law only recognize that only the owner who has the legal rights over the goods can actually transfer the title to the new buyer. Okay, so that is the general rule. So the legal maxim for this particular rule is that nemo dat quod non habet, which means no one can get what he doesn't have. Okay. So meaning to say, if the goods bought from the person who is not the truly the legal owner of that particular goods, the buyer is not entitled to acquire the ownership of the goods. Simply like that. Okay, so this is the general rule. The general rule say that the buyer can only get the title of the goods if the legal owner has the rights or the legal title over the goods. But of course, in law, always there is a exception to the general rule. Always there is an exceptions. So these are the exceptions laid down under the law, where instead of only the legal owner can transfer the title, in some circumstances the law gives some lose its restriction or give some relax to that certain situation, where the third party or sometimes the agents, the third party can actually transfer the title to the new owner, right? So what those situation is, example like first, under the rule of estoppel. So this is very common. Under rule of estoppel is actually developed under the from the rules of equity. If you still remember that the sources of law. So one of the sources of law is English law. So English law divided into two: the common law and rules of equity. So rules of equity is a principle made by the court of law, where it gives that uh, means that if the owner by his conduct or impliedly has consented to the seller to sell the goods, the owner that it then is stopped from claiming otherwise. Sometimes this could happen as a result of the negligence of the part of the owner. Okay, so if you refer to the module, right? I have stated the case syarikat Batu Sinar Sdn Berhad, NUMBC Berhad and another. In this case, the defendant, i.e. the UMBC, had failed to claim the ownership of the tractor. So, and thereby was stopped from claiming that the ownership of the tractor which has been transferred to the plaintiff. Okay, so the difference between the section different between number one and number two. So number one is a little bit general in nature. So number two is sort of like number one. It can be a number one, but in other words, number one, it can happen not only for mercantile agent, but also it can happen for normal persons. So let's say if A puts the goods to the B, saying that you can sell these goods to other person, right? So it means that is fall under number one. But number two is special for mercantile agent, whereby that if the individual puts the goods to the tradesmen or to the agents, business agents, like a car seller, car reseller, something like that. So that is fall under number two. Meaning to say, if you want to buy a car, you sell a car, and then you put the car to the car dealer or car seller, reseller, something like that, used car seller, something like that. So it fall under number two. So that particular reseller can transfer the title to the new buyer. Instead of you yourself that transfer the title. So that is fall number two. Number three is one of the co-owners. Sorry. This is stated under section 38. The goods is transferred to the buyer if one of the joint owners by permission by his co-owners sell the goods to the buyer. Okay, who is in good faith belief that he has the authority to sell. So if you refer to section 28, at the back of the module, it says that if one of the several joint owners of goods has the sole possession of them by permission of the co-owners, the property in the goods is transferred to any person who buys them of such joint owner in good faith and has not at the time of the contract of sale noticed that the seller has no authority to sell. So this by looking at the provision, a little bit confusion. There is a confusion here. In one way, that is state that the goods is several joint owners. So one of the several joint owners of goods has the sole possession of them by permission of the co-owners. By the permission of the co-owners, the property in goods is transferred to any person who buys them of such joint owner. So one statement is said that by permission of the co-owners. But another statement it says that any person who buys them of such joint owner in good faith and has not at the time of this contract of sale notice that the seller has no authority to sell. Notice of such. It seems that this sometimes in certain some situations the co-owner has not, as if that has not obtained the permission of the other owner. Okay. So this is the provision is open to the wide interpretations, whether the co-owner has to get the permission or not to in order to sell the goods to the third party, especially to third party who is in good faith. In good faith meaning to say he has no knowledge at all that the seller has the rights or not the authority to sell of that particular goods. Okay, so what can I say that in these provisions, though it's open to the interpretation, but uh, in a sense that if one of the owners of the goods, want to sell the goods, it must obtain the permission from the other co-owner, right? Okay. So, but however, if the buyer, without asking that whether the co-owner of the seller is whether the co-owner agrees or not to sell, right? Though actually he has, no authority to sell, right? Or doesn't get the consent, to sell. So in this case, the third party or the third buyer who is in good faith, has the uh, the rights, over the goods delivered, unless the buyer knows about it, so once he knows about that the one of the co-owners disagree to sell, meaning to say he doesn't get that title, so that is another situation. Okay. Number 4 is buyer in a possessions, buyer in the possessions. So okay, sometimes the goods is delivered to the buyer, by the seller. Okay. then the buyer, instead of instead of paying the goods to the seller, he resell that goods to the third party. Okay, resell to the third party. So this is means by buyer in a possessions. Buyer in a possessions. Possession mean the buyer holds that goods. So he should have uh, paid for that particular goods to the seller, but instead of he pay the price of the goods, he resell the goods to the third party, who is in good faith, doesn't know that actually the buyer is should actually pay to the original seller, original owner. So in this case, if the third party, if he doesn't know, he's in good faith, means he in good faith doesn't know that actually the buyer has not paid the price of the seller, the price to the seller, then the third party has the rights over the goods. So in this case, the buyer, the one who should actually uh, paid for the price of the goods, instead of the third party. And sometimes number 5, it also happen when the seller in the possessions. When the seller in the possession, it means that uh, the first buyer, actually has paid for the payment, has made a payment for the goods, but instead of the seller delivers the goods to the first the first buyer, he delivered to the second buyer. Okay, delivered to the second buyer. So in this case, as if that the seller got two buyers. One buyer had paid already, but doesn't get he's not given the goods. It's not the but instead of that, the second buyer is obtained the uh, gets the goods. So in this case, the we call as a seller in the positions. So in this case, the second buyer, which is if he doesn't know about the transaction in the first place between the first buyer and the seller, so the second buyer has the title of that particular goods. So what happened to the first buyer is that he has to sue the seller, because for failing to deliver the goods. Okay, unless that the second buyer knows about the first transactions, then the goods has to be returned to the first buyer. Okay, so it also can happen during the business transactions. So we can encounter come across of these issues, especially those seller or buyer who are not actually honored, who are not honest in dealing with the business partners. Number 6 is voidable contract. Okay, so in terms of, as you, if you still remember, the voidable contract is those contract which arises from 4 situations. One is from arising from the if there is a coercion, undue influence, fraud, and also misrepresentations. So for situation where the voidable contract can may happen. So under these situations, right? So how uh, the third party, is it third party? So for example, if the seller, okay, the seller force the buyer A, for example, the buyer A, that particular to buy that particular goods, so that is considered as voidable contract. Okay, so uh, instead of cancelling the contract, the first buyer resell the goods to the second buyer. So in this case, uh, the law actually give an exception lah. So meaning to say, even though the contract is voidable on the part of the first buyer, if he insists to proceed the contract, he can actually re, uh, re transfer the title to the second buyer. Okay, so that is we call that the voidable contract. So there are 6 exceptions, whereby um, the legal what we call that, the legal owner can actually transfer the title. Sorry, the other individual or party which is not the owner of the goods can transfer to the title to the third party. Okay, there's another explanation. Oh, so I got this explanation. You can read yourself. Okay, this is the detail of the explanation. You can read yourself. Okay. So bona fide buyer. Bona fide buyer means to say the buyer who is in good faith. Bona fide. Bona fide. Or bona fide. Okay, let's say example like this. The seller, by fraud, the seller uh, got the goods by misrepresentation or fraud, from the seller, right? The first seller, right? So and then transfer the title to the third party. So this is voidable contract. Okay, I think so. Right. Okay, this one has been explained already. Okay, quantity lesser, quantity larger. Okay. Okay, this also has been explained. Okay, so in terms of rule of acceptance, rule number one is buyer is not bound to return rejected goods. So if it happened, for example, the buyer receive the goods which is less quantity than ordered, then the buyer is not has no responsibility actually to in term of cost lah, in term of cost to return the rejected goods. So it is will be borne by the seller. Okay. So it just on his part, he just communicate to the seller saying that he want to reject the goods. So meaning to say the seller who is responsible to actually to bear all the costs or any kinds of transactions. So you know uh, to what you call it for the rejected goods. Okay. Rule number two, liability of buyer for neglecting refusing delivery of goods. When the seller is ready and willing to deliver the goods and request the buyer to take delivery and the buyer doesn't within a reasonable time after such request take delivery of the goods, he is liable to the seller for any loss occasions by his neglect or refusal to take delivery and also reasonable charge for the care and custody of the goods. So this is case whereby both have agreed for that contract of sales, right? And then when the seller is ready to deliver the goods, eh? So what? But the buyer, the buyer actually failed to actually um, what you call it to take for the delivery, to accept the goods. So bear in mind, sometimes delivery doesn't mean that the responsible for the seller to deliver the goods at your doorstep. Sometimes in the contract it says that delivery only takes, for example, in the warehouse. So if it is agreed that the means of delivery, not at the doorstep of the buyer, but instead of that at the warehouse, then the buyer has to take that responsibility. So we need to say in the contract, for example, delivery only, let's say the seller only delivers the goods to the warehouse. So the other transaction will be taken uh, by the buyer. So in this case, if the buyer doesn't take any actions for that, so the buyer has to bear any loss. Okay, for failing to take that delivery. So right, so bear in mind, so everything depends on the contract. But of course, if a normal customs and customs of business, for example, if you buy from the online Shopee, for example, so of course it's in terms of delivery is on the part of the seller, because it is a custom, custom whereby you mean to say the seller has to deliver the goods, until at your doorstep, right? So that is the custom for that particular good. But some certain contracts, other contracts might be different. So it might, in terms of delivery, is not at the doorstep of the buyer. It might be anywhere. Okay. Okay. This is the rights of unpaid seller. The rights of unpaid seller. If you look at the refer to the our module, right? It is stated the rights of our unpaid seller or remedies for the unpaid seller. So it happens when, especially, uh, there is an agreement, and then the buyer agrees to buy the goods, but he failed to pay the price of the goods. Sometimes he just put the deposit, for example, right? So the payment has not been fully made. eh? So in this case, the seller, under section 46, has certain right. One is, we call it as a lien on the goods. So mean this, a lien means he has the right to hold the goods, in his possessions, until the payment has been paid. Number two, rights of stopping the goods in transit. Okay. Alright. So number two, a right of stopping the goods in transit. It means that sometimes the seller use the courier. So the courier. So meaning to say, if the goods still in the possessions of the courier, so the seller can just communicate to the seller to stop the goods, not to actually transfer or deliver the goods to the buyer. So that is what it means. Number three, a right of resale. So if after a reasonable time, the seller doesn't give any response, or the buyer doesn't give any response, feedback, whether or not to pay for that, and then the seller has the right to, of course, to resell the goods to other buyer. Okay, this is unpaid sellers lien. So what is meant by sellers lien? Okay, so it means that the unpaid seller of goods who is in possession of them is entitled to retain possession of the goods until the payment or tender the price the payment have been made. So where the goods have been sold without any stipulation as to credit, right? As to credit, uh, where the goods has been sold on credit but the terms of credit has expired, or number three, where the buyer it becomes insolvent. So this is where the situation that render the seller to retain the possession of the goods. So this is a part delivery. Part delivery is not so important. Okay. So this is a situation where uh, the seller has lost its lien's rights. So when the seller delivers the goods to the carrier for the purpose of transmission to the buyer without receiving the right of disposal of the goods, meaning to say it doesn't communicate to the carrier whether or not to deliver the goods to the buyer, and then the carrier actually has delivered already. Now B, for example, when the buyer or his agent lawfully obtain possession of the goods, then the seller has no rights of liens. Or in number C, if there is a waiver. So we need to say sometime waiver means the seller give that uh, you know uh, free of charge to the buyer. So if there is a waiver, then of course no rights of the end. Okay, stoppage of transit I have explained already. Okay, this is remedies available to the buyer when a seller is in breach of sales of goods. Okay, one is damages for non-delivery, where the seller wrongfully neglect or refuses to deliver the goods to the buyer. The buyer may sue him for damages for non-delivery. Right. Number two, action for specific performance. So this is action is obtained from the court, from the high court. So meaning to say the buyer may we call it uh, apply the decree from the high court that the seller has to perform the act of delivery. Okay. And number three, remedies for breach of warranty, where there is a breach of warranty by the seller or where the buyer elect to treat a breach of condition as a warranty, the buyer is not entitled to reject the goods. Okay, remedies for breach of warranty is in terms of in the damages, the kind of damages, money, in type of money. All right. Okay. In this topic and sales of goods, I also mention several cases. One is Roland and Deval, and the second one is Bill and Taylor. If you refer to the module, okay, it is mentioned Bill and Taylor. There is case of Bill and then Bill and Taylor and under page 82. Right. So under the sales of descriptions. Where in this case the buyer was interested in the car, in the car sales advertisement that referred to description as 1961 model. However, subsequently the car delivered was not fully described as 1961 model, but instead of that it's other kind of model. So it was held that the seller had breached the implied warranty conditions of the sale of descriptions, because buyer depends on the description given by the seller in the making of decision to buy the car. So you need to say the goods delivered doesn't match to the descriptions at the before the contract of sale be made. So another case is Ganda edible oils in Berhad against Transgen BV. So this is pertaining to the delivery of goods which is less in quantity, as agreed, right? So you can refer yourself, page 85. So for Roland and Devil, maybe you can find this case in the, you can try to Google, right? Okay, Okay, so I think that's all from me. If you have questions, so you can raise up in the class. Thank you very much.